DHS told the public that new cadets receive all the training they need to perform their duties, that no critical material or standards have been cut. This is a lie. ICE made the program shorter, and they removed so many essential parts that what remains is a dangerous husk. No reasonable person would believe a training program suddenly cut nearly in half could meet the minimum legal requirements.
I am so damn tired of being lied to. I don't think I can deny it anymore. You can stick to your story if you think it flies, but I'm not gonna buy it anymore.
Hello, my friend, and thank you for listening to the 334th episode of Congressional Dish. I'm your host, Jennifer Briney. And today's episode is once again going to be about immigration and customs enforcement because that agency appears to be somewhat out of control. The reason we know this is because there was a shadow hearing that was held on February 23rd, 2026 by Democrats from both the Senate and the House. Now, these so-called shadow hearings are not official hearings. They don't appear in the congressional record, and they're kind of like if you know situations. But the shadow hearings are necessary right now because the Republicans, who control both sides of Congress at the moment, are refusing to do any kind of real oversight of the Trump administration. And so, ironically, the only real hearings that are taking place right now in Congress are the fake hearings. And in this shadow hearing, the testimony that served as the catalyst for this episode, in this testimony, you're going to hear from a guy who was training ICE officers until he resigned in order to testify to Congress because he was so horrified by what he saw and did. And his resignation happened the day after Todd Lyons, who is the acting director of Immigration and Customs Enforcement. Well, he resigned the day after Todd Lyons finished testifying to both the House and the Senate, during which Todd Lyons told Congress,
the meat of the training was never removed. The timeline was, we took training from 5 days a week, 8 hours a day, to 6 days a week, 12 hours a day. In addition to that, training is different in the fact that before officers even go to the Federal Law Enforcement Training Academy, there's pre-employment training, which we never had before. And on top of that, we've adapted our on-the-job training program, which is much like a city or state field training officer program that once they are removed from the Federal Law Enforcement Training Academy, have graduated, before they return to their field offices, they're assigned a field training officer, and that's continued on after that.
So Todd Lyons went to Congress and made it sound like ICE actually expanded their training of new officers. But after hearing that, ICE trainer Ryan Schwenk quit his job so that he could publicly tell Congress,
I am here to convey to the public the danger that is being created at the ICE Academy. I know from my conversations with many facility members, many of the faculty, that I am not alone in my fear. Law enforcement is a deadly serious business. It is not a place for shortcuts. Deficient training can and will get people killed. It can and will lead to unlawful arrests, violations of constitutional rights, and a fundamental loss of public trust in law enforcement. ICE is lying to Congress and the American people about the steps it is taking to ensure its 12,000 new officers faithfully uphold the Constitution and can perform their jobs.
And that's the testimony I'm going to share with you today. In the same shadow hearing, the Democrats also took testimony from a woman whose home was raided by Department of Homeland Security agents in order to attempt to deport her husband. And in the process, it seems reasonable and credible to believe that the Department of Homeland Security violated the Constitution. And so today you're going to learn exactly how the Constitution is likely being routinely violated lately. You will learn how ICE officials have made violating the Constitution official ICE policy, and you will learn what kind of bullshit the Department of Homeland Security authorities are spewing in order to justify violating the Constitution as a matter of policy. This is going to be one of the most important episodes of Congressional Dish that I've produced during the second Trump administration. And I want to be crystal clear when I tell you that if the Republican Party had their way, this episode would have been impossible for me to produce. Because not only has the Republican Party in the 119th Congress completely abdicated their responsibility to conduct oversight over the executive branch simply because their party's candidate sits in the White House and they are therefore refusing to hold public hearings in the official record with whistleblowers who are willing to sacrifice their livelihoods and careers to tell us what they know. But on top of that, the Republicans in Congress are also refusing to even participate in the shadow hearings when they happen. They simply don't want to hear this information. This episode exists because the Democrats did a good job on February 23rd in conducting this shadow hearing, the third such hearing that the Democrats have held that I know of. I spend many hours on this podcast pointing out congressional failures, but let's also acknowledge success. The Democrats did good here. I learned a lot about ICE in the shadow hearing and in the, I think, 4 other hearings that I watched in order to produce this episode. And today, you will too. And we have a lot to get to today, so I'm not going to spend a lot of time on this. But I do have to tell you how this podcast gets funded, because when I don't do that, it doesn't get funded. And the reason for that is that it's funded by you. It's funded by a lot of people, actually, but that does include you. And today I want to appeal to your sense of duty for why you should fund this show. Because quite frankly, I am high on my own supply with this episode, and I want to give you some of this. Because have you in any way, when thinking about the state of the United States lately, felt kind of helpless? Like our government is out of control and there's nothing you can do about it? Because if you have, you're not alone. I feel that all the time. But in producing this episode, I've got to tell you that producing this episode felt like taking medicine for helplessness. Because together, we are spreading information that the bad guys don't want spread. We are doing something here. I think we're helping. And that's a we statement because I can't do this without you. I can't do this without the money that pays my team. I can't do this without the therapy that comes from your Venmo dings. I can't do this without the knowledge that comes from every new Patreon sign-up notification, that comes with every paper check, every Zelle, every Cash App, every PayPal, every single donation, every single month. Every single one of them reminds me that I'm not alone. I'm not alone in this project. I'm not alone in my feelings, and I'm not alone in my desperation to help. And I know we can't do much right now because we don't have power. That's true. But we can do this. We can create this podcast together, which I know is listened to by people who can change things, who work on Capitol Hill. We create this podcast together. And I really do think those of us who are doing this are helping. And that feels good. And so if you want some of this medicine, if you also want to feel good, help me do this and pitch in what you can. And also, please tell your friends about the show, because this is information we need spread far and wide. Okay, so let's get started where we left off with episode 329. That was the episode about the other shadow hearing that was held by Democrats, during which we heard about Department of Homeland Security, specifically ICE and Border Patrol agents, using violence to arrest and imprison U.S. citizens who had done nothing which could legally justify it. Well, all of that happened because the so-called big, beautiful bill funneled an enormous amount of money to ICE and expressly gave them permission to expand their workforce and their ability to cage a lot more human beings. And if you haven't heard that episode already, I highly recommend that you also listen to our current #1 most valuable episode as paid for by our executive producers, which is episode 320 about the one big beautiful bill, specifically the one labeled A Dangerous Law. There were 2 episodes about the big beautiful bill. But the Dangerous Law episode will tell you exactly what the Republicans did in the big beautiful bill to set up the situations we find ourselves learning about today. I read the law for you. It's bad, and you should know the details. But anyway, following up on those episodes, we know that ICE is well-funded and is currently hurting people, American citizens and immigrants alike. And in a House Committee on Homeland Security hearing on February 10th, we learned from the acting director of ICE, acting, by the way, because he hasn't been confirmed by the Senate for the job. But acting director of ICE Todd Lyons testified with some numbers that shined a light on exactly how many people, according to the Department of Homeland Security itself, its actions have affected so far during Trump Part 2.
The President tasked us with mass deportation, and we are fulfilling that mandate. Thanks to the resources provided by this Congress, we are ramping up detention capabilities and removal flights daily. In the last year alone, we conducted over 475,000 removals.
So 475,000 people who were here a year ago are no longer here. And so out of those 475,000, here's how many of them were forcibly removed.
From January 20th, 2025 through January 20th, 2026, ICE has conducted nearly 379,000 arrests. Among those arrests were more than 7,000 suspected gang members and over 1,400 known as suspected terrorists.
Okay, so looking at those numbers, what that tells me is that if 379,000 people were arrested and 7,000 were maybe gang members and 1,400 were maybe terrorists, for a total of 8,400 maybe worst of the worsts, that means that less than 3% of these arrests were of the worst variety. But what if we broaden the range to any kind of crime? So like weed smokers, DUI getters, traffic ticket holders, any kind of criminal, even suspected, even the people that have pending convictions. What if we also expand it to those kinds of maybe criminals?
If you look at what ICE has done, more than 60% of every individual that is in ICE custody has a pending or a conviction on a criminal charge.
Which means that about 40% of the people ICE has in custody do not have even a pending criminal charge. 40% of 379,000 arrests is more than 150,000 people. That's a lot of arrests of non-criminal people. And we know that too many of those arrests have not been chill. Here's the not official number from the only not official investigation that is possible in this Republican Party-controlled Congress. Here's Representative Robert Garcia, a Democrat of Long Beach, talking in the shadow hearing that took place on February 23rd.
Now, as of February of this year, Oversight Democrats have documented over 530 credible and verified instances of possible abuses and misconduct by President Trump's federal immigration agents, including 224 incidents just with use of force.
And we know that two of those uses of force against U.S. citizens Renee Good and Alex Preddy resulted in their deaths. We all saw the videos. Well, the Democrats, correctly in my opinion, thought it would be a reasonable inquiry for Congress to try to find out why ICE has been using force so recklessly. And it turns out there are at least two explanations. One, training of ICE officers is leaving much to be desired. And two, it's ICE policy to violate the Constitution. And we now have a memo to prove it. And so here's the opening statement of whistleblower Ryan Schwank. And settle in, because this is a long clip, and I'm just going to let him cook.
My name is Ryan Schwank. I swore an oath to uphold the Constitution when I joined ICE on August 1st, 2021, as an assistant chief counsel. I followed that oath for 4.5 years, working side by side with ICE officers. And I followed it when I resigned on February 13th, 2026, a little over a week ago, so that I could speak to you today. I am here because I am duty-bound to report the legally required training program at the ICE Academy is deficient, defective, and broken. 5 months ago, I was asked to teach the law to new cadets at the ICE Academy in Glencoe, Georgia, where ICE is training its new, inexperienced recruits. I volunteered, those without law enforcement training, I volunteered to take on this assignment based on my experience in law enforcement oversight, including at the state and local level prior to my work with ICE. On my first day, I received secretive orders to teach new cadets to violate the Constitution by entering homes without a judicial warrant. For the last 5 months, I watched ICE dismantle the training program, cutting 240 hours of vital classes from a 584-hour program. Classes that teach the Constitution, our legal system, firearms training, the use of force, lawful arrests, proper detention, and the limits of officers' authority. For example, they ceased all of the legal instructions regarding use of force. This means that cadets are not taught what it means to be objectively reasonable, the very standard which the law requires them to meet when deciding whether or not to use deadly force. Our jobs as instructors are to teach them so well that they can make split-second decisions about what they can and cannot do in life or death situations. Yet, in the name of churning out an endless stream of officers, DHS leadership has dismantled the academic and practical tests that we need to know if cadets can safely and lawfully perform their job. All to satisfy an administration demanding they train thousands of new officers before the end of the year. DHS told the public that new cadets receive all the training they need to perform their duties, that no critical material or standards have been cut. This is a lie. ICE made the program shorter, and they removed so many essential parts that what remains is a dangerous husk. No reasonable person would believe a training program suddenly cut nearly in half could meet the minimum legal requirements. These aren't abstract rules. They're required in regulations such as 8 CFR 287G1. Congress requires immigration officers to meet minimum standards for a reason. ICE cannot lawfully perform their duties, make arrests, carry weapons, and use force without passing appropriate training. New cadets are graduating from the academy despite widespread concerns among training staff that even in the final days of training, the cadets cannot demonstrate a solid grasp of the tactics or the law required to perform their jobs. Without reform, ICE will graduate thousands of new officers who do not know their constitutional duty, do not know the limits of their authority, and who do not have the training to recognize an unlawful order. That should scare everyone. DHS assures the public these cadets can get the job training on compensate for anything missing at the academy. This is a lie. Many graduates go to their home office just long enough to get their gun, their badge, and their body armor before deploying to places like Minneapolis and other ICE operations with minimal supervision. It's shocking that anyone would think this is safe or responsible. And this pattern of lies is not isolated. It extends beyond the training program to include deceiving Congress and the public about the rules followed by ICE officers once they graduate.
Okay, so there was a lot there, so let's zoom in first on the training. Now, as you already heard the acting ICE director, Todd Lyons, testify in the opening of this episode, the Department of Homeland Security is saying training hasn't been cut. And when they speak about it, they talk about number of hours.
The meat of the training was never removed. The timeline was, we took training from 5 days a week, 8 hours a day, to 6 days a week, 12 hours a day.
And that same exact line was repeated more than once in 2 separate hearings by then Department of Homeland Security Secretary Kristi Noem.
Senator, our ICE officers are trained when they come on board the department 56 days. We've changed the format of those days. Instead of 5 days a week, 8 hours a day, they now do 6 days a week, 12-hour days. We also give them 28 days of on-the-job training.
But Ryan Schwenk, the whistleblower, he didn't focus much on the total number of hours. Instead, his focus was centered on what was being taught during the training hours.
What was taken out of the training were classes on use of force, specifically classes taught by the legal department, as well as classes taught by other units. What was taken out was almost 16 hours of firearms training, classes that teach them how to use their weapons correctly and safely. What was taken out were classes on how the Constitution works, what the constitutional requirements are for their job, and the constitutional limits on their authority. In fact, the class where we talk to the officers and teach them about the rights of protesters was cut from a 2-hour program into about 10 minutes. They got shoehorned into a lecture on what the concept of a seizure is. There are others. There are many other classes that were cut, but I think these are the most critical for your question.
Which makes me raise an eyebrow to this testimony given 3 weeks earlier by the acting director of ICE, Todd Lyons, in response to Representative Andrew Garbarino of New York.
Director Lyons, are your officers trained regarding the difference between a protected protest and what is unlawfully impeding law enforcement?
Yes, sir. Deportation officers and special agents are taught at the Federal Law Enforcement Training Center. They are taught in defensive tactics, personal safety, but as well as laws to include First, Second, Fourth, Fifth, 10th, 14th Amendment. The officers are trained before they go out into the field, and then while they're in the field. They are specialized training with disturbance control and other special tactics.
But back to the whistleblower, the ICE trainer. He also focused on how the training was being conducted.
So what the Academy does is we have two types of tests. We have multiple choice exams and we have practical exams. With the multiple choice tests, the cadets went from having to do them in a closed book format where they had to depend on what they had learned and memorized to doing them open book and open note, where essentially the only thing we were really testing them on is their ability to search a document to find the answers. But more important than that, we took away the practical testing. Under the old rules, we took everything they learned in the academy, all that they learned, and we made them apply it. We put them through a range of scenarios where we could test, do they understand when they can enter a home or not? Do they understand when they can make an arrest or not? And if they showed that they did not know that, we could fail them and send them back and make them try again and demonstrate their knowledge. And if they failed twice, out of the academy. And maybe 6 months later, 90 days later, they could come back after they demonstrated to their home office that they were ready. But today, no matter how badly a cadet does at those practical exams, no matter how many mistakes they make, no matter how egregiously they violate the law during a practical, we graduate them.
So basically, he's saying that ICE is making it impossible for new cadets to fail, which means that even the losers are being given authority, power, and guns. Although, as angry as I am at the leadership of the Department of Homeland Security and ICE, and the Trump administration by extension, the individual officers, here's what the guy who was training them had to say about them.
I was genuinely surprised by two things about the cadets I saw at the academy. One was that I routinely met cadets who genuinely wanted to learn and understand what they were supposed to do, that they wanted to do their jobs correctly. I have no doubt that if given the opportunity, they would do that. But they are cadets who come from a variety of backgrounds. I've had cadets who were 18 years old. I had a cadet who we celebrated her 19th birthday in one of our classes. We have cadets who don't have college degrees. We have cadets for whom English is not their primary language. I was genuinely surprised by the sheer number of cadets we had that were first or second generation immigrants. And these are all people who I think want to do well, but they don't have the background, and we're not giving them the training to do this job correctly. We're not giving them the training to know when they're being asked to do something that's not supposed to do, something illegal or wrong.
Now, nothing excuses violence or violating the Constitution, but the individual officers are symptoms of the broader systemic breakdown. Because when good people are trained poorly, these are predictable results.
I have seen examples of cadets who have drawn their firearms on each other by accident. I have seen cadets, and this is in the last day or two of training, so this is at the end of the program. I have seen cadets make arrests of individuals that had committed no crime and for which there was no cause to make the arrest, despite the cadet allegedly having been taught the law related to the crimes involved. I have seen officers apply excessive force in these training scenarios, where they have made arrest attempts that involved drawing their firearm, using pepper spray, various events that they were not authorized to do and which were not justified by the circumstances, in which no objectively reasonable police officer would have done what they did. And they still graduated. I have seen cadets, and this was a moment that stuck out to me at the academy. I saw a cadet in a scenario where we had bystanders who were allegedly filming or recording what was happening, pull out pepper spray and pepper spray a bystander. And when we asked the cadet afterwards why they did it, their answer was, it's because I've seen what we're doing in Minneapolis. It doesn't matter what we teach them about the law if what they watch on television and on Reddit and on the internet tells them that they can get away with things. The academy can teach them till they're blue in the face. But if they see that in practice the real rules are different than what we're teaching them, they follow the rules that they see.
Reality matters more than words on paper, especially right now. And here's what the street is teaching. which is overriding even the diminished training being given by ICE. Here's Representative Emily Randall of Washington questioning our ICE trainer turned whistleblower Ryan Schwenk.
Thank you. What about racial profiling? Can you tell us what guidance was provided to ICE agents regarding racial profiling?
Yes, Representative. In the training material that we taught, the material calls for the department to follow the Department of Justice's guidelines on the use of race and other factors in law enforcement operations. But in practice, what the cadets are taught is to follow what's called the Kavanaugh stop. That is that they are allowed to use race as a factor, not the sole factor, but a factor in their operations.
And yes, that is a reference to Supreme Court Justice Brett Kavanaugh, one of the justices picked by Donald Trump the first time he was president. Brett Kavanaugh is the one who allegedly used to get wasted and fondled the boobies of unwilling women for whom he provided the ick. Well, that same guy, Brett Kavanaugh, as Supreme Court Justice, wrote an official opinion explaining his September 2025 vote to lift a lower court's order to ICE, prohibiting them from using physical appearance and language use, among other factors, when deciding to stop, question, and cage people suspected of not having their proper papers. That Supreme Court decision has paved the way for roving patrols of ICE goons who are harassing based on their own assumptions about our races and therefore citizenship status. And those kinds of stops, because of that opinion, have been nicknamed after Brett Kavanaugh. Kavanaugh stops. Seems fitting to me. But it's another example of how the behavior of officers on the ground is determined at the top. It's being determined by the Trump administration, by the heads of ICE and the Department of Homeland Security, by the Supreme Court. And so individual officers, of course, should be held accountable when they abuse their power and hurt people. 100% they should. But focusing on the individual officers, so like organizing to scream in their faces, to dox them, to harass them out of their homes, it's counterproductive for two reasons. One, it allows law enforcement to credibly brand themselves as victims. Here's Acting ICE Director Todd Lyons.
We are facing the deadliest operating environment in our agency's history. In fiscal year 2025, death threats against ICE personnel increased more than 8,000%. Assaults on officers have skyrocketed over 1,400%. One officer in Minnesota had his finger bitten off by a protester, egged on by elected officials characterizing our officers as Gestapo or secret police. The families of ICE personnel have been made to feel unsafe in their homes. I know this firsthand because my own family was targeted.
And Republicans in Congress have proven themselves to be very sympathetic to those types of stories. But then, too, this is also counterproductive because the individual officers are not the root problem. Here's our ICE trainer turned whistleblower, Ryan Schwenk.
If the problem was that simple, that we just had a bunch of people who don't like foreigners and want to remove them from our country and it was all white supremacists, it would actually be a very easy problem to solve. You would just fire them all. But that's not the root problem. The root problem, Senator, and I say this because there are hundreds, if not thousands, of ICE officers who are immigrants themselves or the children of immigrants. I am the child of an immigrant. The root problem is that we have trained a federal law enforcement agency to go out and perform a job they are not equipped or trained to do. We have sent out officers who are essentially designed and trained to be civil enforcement, to do criminal enforcement, to be crowd control, to be a tool to be used by the administration to bring fear into neighborhoods around the country. And the officers that they are recruiting now are less trained and come from less capable backgrounds than the officers who were already there. When we look at the Renee Good or the Alex Preddy shooting, those are not inexperienced officers. Those are officers who've been there for a while, who have knowledge of how to operate and do what they need to do. The officers who entered into Ms. Gibson Brown's home from the pictures you showed, probably experienced officers. Everything we've seen today, everything we've seen through today, has been done by officers who should know better, who should know at the end of the day that it's their personal responsibility to uphold the Constitution, that they took an oath to it. And I'm going to tell you right now, Senator, that at the Academy, we took out the class that tells the officers they have an oath to the Constitution. We took out the class that tells them they have a duty to uphold the Constitution. We took out the class that tells them that they have personal responsibility. That at the end of the day, no matter what orders they get from their supervisors, it's on them to do the right thing. And that's the root problem. These cadets and these new officers don't have any firmament, any basis on which to stand. They don't know what they don't know.
Which tells me that this problem is only going to get worse as these poorly trained agents get put out onto our streets. And so when I look at the root of the problem is the Trump administration. It's the people that Donald Trump has empowered at the top, and the Republicans in Congress that have funded them with outrageous amounts of our money. And for their part, those empowered, well, here are their responses to the accusations against them. First, here's their response to the accusation that the Department of Homeland Security is hiring and training ICE agents at an unprecedented pace. They don't deny it. They're proud of it. Here's the acting director of ICE, Todd Lyons.
I am also proud of our agency's unprecedented hiring campaign that led to hiring of more than 12,000 officers and special agents in less than a year.
And as for the claims of the ICE trainer who sacrificed his livelihood to tell us what he saw, well, here's Representative Andrew Garbarino of New York questioning Todd Lyons, the acting director of ICE.
So let me get this go for ICE officers. The curriculum has stayed the same, but it's now a quicker training. The timeline has moved up?
That's correct, sir.
Okay, but the curriculum is the same.
Yes, sir.
So it seems to me that if this investigation continues, which the Democrats do seem hell-bent on ensuring it does, well, it seems to me like a curriculum change is the type of thing that can be proven eventually. And so someone is committing perjury. Who do you think it is? For what it's worth, the whistleblower is mincing no words. Here's Senator Richard Blumenthal of Connecticut questioning Ryan Schwenk.
Just in the time that we've released these documents, DHS has come forth with a statement. I'm going to quote it. Under these new improvements, candidates still learn the same elements and meet the same high standards ICE has always required. No subject matter has been cut. Is that statement accurate, Mr. Schwenk?
Senator, that statement is not accurate. Not in even the slightest sense.
It is untrue. Would you agree?
Sir, I would call it a lie.
And that's not the only possible lie that high-ranking DHS officials have told Congress. It's possible that Todd Lyons also lied about a scandalous memo that instructed ICE agents to ignore the Constitution. But before I get to that memo, you need to understand what is happening in the real world, the situations that the memo is authorizing. And so for that, I want you to hear highlights of another witness in the shadow hearing.
My name is Tiana Gibson Brown, and today I stand before you not just to speak, but to bear witness. I am here to share a deeply personal and painful experience, how me and my family's Fourth Amendment were violated.
The violation occurred as ICE agents arrived at her home to arrest her husband, Garrison. Garrison Gibson Brown had emigrated to the United States from Liberia as a child when his parents fled the country because of a violent civil war. Again, Garrison was a child with no control over the decision to come here. In 2008, Garrison was convicted of a drug use offense, but that offense was later dismissed by the courts, which means he has a clean criminal record. Regardless, a deportation order was issued for Garrison in 2009. But for 17 years, he has been allowed by our courts to remain here legally in the United States with his family. He followed every rule and attended all of his court hearings. In fact, just a few days before the ICE goons showed up at his house, he had attended another court hearing. In other words, Garrison was not a convicted criminal, and he was here legally according to our own courts. And yet,
Garrison went to the door and asked the officers through the closed door about why they were at our home. Followed with this, he asked them if they had a warrant. The officers at the door told Garrison that they did have a warrant, and it was signed by a judge. When Garrison asked to see the warrant, the officer simply ignored his request. Although my husband and I may not be experts in the legality of some situations, we are aware of the fundamentals and understood how the Fourth Amendment shielded us from arbitrary government searches and seizures. Given this, my husband repeatedly requested to see the warrant. The circumstances outside of our home only intensified. We knew our rights, though. We knew no one could just barge into our homes without a warrant because this space was ours. The officers started surrounding our property. 10 officers approached my front door. They looked like SWAT agents, holding each other's shoulders like a barricade. The officers walked up to my door and started ramming the door. They hit the door 3 times until the door popped open. My stomach fell. I heard the door pop, and I realized we were no longer protected. Far away from ever experiencing anything like this, we've never known anything of the sort. The officers stood at the door, and they were pointing their guns at us. 10 officers that were all armed were standing in front of me and my family. Words can never be sufficient for me to portray what sorts of horror we felt in this moment. I stood between the officers and Garrison, and I asked the officers yet again to show me the warrant. Despite all of this, they did not show me anything. My daughter and my little cousin, both children, were rushed in the room by my sister and were told to hide in the closet. The fear in my daughter's eyes is something you can't imagine.
And here's what happened to Garrison after he was forcibly removed from his own home in front of his terrified 9-year-old daughter. Here's Representative Rashida Tlaib of Michigan questioning Mrs. Gibson Brown.
The day after your husband was illegally taken from your home, a federal judge ordered that he not be removed from Minnesota. Is that correct?
Correct.
Is that what happened?
He went to Texas. They took him to Texas.
No, they took him.
Yeah.
Kidnapped him and took him to Texas.
Yes.
Did ICE quickly realize their error on their own?
No.
No. Your attorney had to confront Homeland Security. Is that correct?
Absolutely.
On January 15th, a federal judge found that ICE had violated your husband's rights by illegally breaking into your home and detaining him, and the judge ordered his release from the detention. Is that correct?
Yes.
But after your husband was released, he was re-detained for a few hours at the Ripple Federal Building. Is that correct?
Yes.
Who's responsible for ordering that your husband be re-detained?
They said it came from the White House.
No, per federal agent, we know for a fact the order came from Stephen Miller. Did you know that?
Yes.
And so just like they did with Kilmar Abrego Garcia, who was deported to an El Salvadorian torture prison due to an administrative error, after he was returned to the United States after our courts ruled in his favor, he has been a target by a White House that refuses to ever admit wrongdoing. And so the White House, after courts ruled that Garrison Gibson Brown's rights were also violated, he's now also being targeted by a vengeful White House. Unfortunately, the end of Garrison's story appears to still be unwritten. But how did this happen in the first place? How was his house raided and his rights violated? Did it happen on accident, or was this on purpose? Well, it turns out that the ICE agents did have something that they called a warrant, but it wasn't a real one. Instead of getting a warrant issued by a judge in the judicial branch of our government, the Department of Homeland Security is issuing warrants to themselves, so-called administrative warrants, which means that what happened to Garrison Gibson Brown was no accident. It was policy. And the legality of that, well, listen to this testimony from another shadow hearing witness.
My name is Steve Bunnell. I was the general counsel of the Homeland Security Department from 2013 until 2017. I previously had served 17 years as a career federal prosecutor, including several years as the chief of the criminal division in the U.S. Attorney's Office here in Washington, D.C. I am one of 6 former general counsel and acting general counsel of DHS who recently co-authored a guest essay in the New York Times disagreeing with ICE's new policy of relying on administrative arrest warrants to forcibly enter private residence to arrest someone for a civil immigration violation. The 6 of us included top DHS lawyers from the Bush administration, the Obama administration, the first Trump administration, and the Biden administration. This is a group that doesn't agree on policy issues always, but we all agreed on this point. The judicial warrant is a requirement of the Fourth Amendment, and it applies to ICE just like it applies to every other federal, state, and local law enforcement agency. It is a basic principle of the Fourth Amendment that searches and seizures inside a home without a judicial warrant are presumptively unreasonable. Indeed, as Mr. Schwenk just said, the Supreme Court has stated that the physical entry of the home is the chief evil against which the working of the Fourth Amendment is directed. The law is also clear, as Representative Garcia pointed out, that, the law is also clear you can't enter someone's home without a warrant that's been issued by a neutral and detached magistrate or judge. In other words, the police can't sign their own warrants. And as Representative Garcia noted, it's important to point out that in the context of immigration enforcement, the Fourth Amendment says the people have the right to be protected from unreasonable searches and seizures. It doesn't say citizens, it says the people. It's thus well established that the Fourth Amendment applies to everyone within the physical boundaries of the United States, including immigrants who are not lawfully present. ICE claims that its general statutory detention authority, combined with a final removal order by an immigration judge, is sufficient to satisfy the Fourth Amendment. But that argument doesn't work. Immigration judges are not neutral and detached judicial officers within the meaning of the Fourth Amendment. They work for the executive branch and are subject to the control of the President and the Attorney General. Immigration judges also lack the statutory authority to issue warrants, either for an arrest or for a search.
And then later in the hearing, in response to questions posed by Senator Catherine Cortez Masto of Nevada, Stephen Bunnell clarified what ICE is actually tasked with doing.
I think there is some confusion, certainly in the public discourse, about what ICE is doing when they're out making these arrests. They are not enforcing criminal law. They're not going after somebody who's a suspected murderer or rapist who's out on the lam, and they're not arresting them so they can be prosecuted and put into jail. They are going out to detain and remove that person out of the country. They're from Mexico. They'll go back to Mexico and they'll be set free.
Not to be detained indefinitely.
Long enough to be removed, basically. Sometimes that is a long period of time. There are lots of people who are subject to orders of removal, like Mr. Gibson, who are not a public safety risk, who are not a flight risk, and therefore are not detained. They're released into the community with conditions. And, in his case, he was adhering to those conditions for 17 years. These are not, in his instance, these are not the worst of the worst. These are not dangerous people. But they have civil rights. They have constitutional rights just like everybody else.
And so, if anything, ICE actions are not emergency actions that would require a runaround of the judicial branch. ICE agents are not saving us from a ticking nuclear bomb. The requirement to get a judicial warrant has no good reason to be waived, and yet that's exactly what they're doing. And from the top on down, they are telling Congress that they think they have the power to do this. Here's Senator Chuck Grassley of Iowa in a March 3rd hearing during which the witness was the then head of Department of Homeland Security, Kristi Noem.
For the record today, please briefly discuss how the administrative warrant works and how often they're used.
Well, an administrative warrant is utilized on a regular basis because it's the process that Congress has given us. It's the process in immigration law that you've given us to ensure that someone is returned back to their home country. And I would say that most of the time when it gets talked about, it's inaccurate. In the 400,000 cases that ICE has used these administrative warrants, only 28 times have they been used to enter a home. So it is the legal process that we have, that we follow as given to us by Congress, and it's been affirmed by the Supreme Court as the correct way to follow the law. We will continue using this tool as it's important in the duties that the Department of Homeland Security is responsible for.
She slapped an only on it, but what I heard was the Secretary of Homeland Security admit in Congress that her department has entered our homes 28 times using these NADA warrants. That's 28 possible violations of the Constitution, which is 28 too many. And her rationale for doing so has some major problems. So first, she claimed that,
well, an administrative warrant is utilized on a regular basis because it's the process that Congress has given us.
Administrative immigration warrants do exist in federal law and are routinely used by immigration authorities to arrest people for civil immigration violations. But their authority for how they can be used is limited. Kristi Noem was claiming powers beyond what the law allows by saying that administrative warrants can be used to enter people's homes. Courts have been crystal clear that they can't. And therefore, by saying that the Department of Homeland Security used administrative warrants to enter our homes only 28 times, she just admitted that the Department of Homeland Security broke the law 28 times, a number that itself cannot be verified as we have no idea where she got that from. And then there was another problematic claim by her when she said,
and it's been affirmed by the Supreme Court as the correct way to follow the law.
And this claim by Kristi Noem appears to be straight up false. In fact, the Supreme Court has repeatedly ruled that law enforcement generally cannot enter a home without a warrant issued by a judge, and that administrative warrants do not qualify because they are issued by the executive branch rather than a neutral judge. And if you want to know in exactly what case the Supreme Court reinforced our Fourth Amendment rights, requiring law enforcement to get real warrants before entering our homes to make an arrest, check out Payton versus New York, which is, of course, in the show notes for you, along with a bunch of other sources that are proving all the things that I'm saying. But in that case, Payton versus New York, a man named Theodore Payton was suspected of murdering a gas station attendant. The police then went to his house without a warrant, and because they had probable cause, entered his home using a crowbar and collected evidence against him. The New York state courts held up the warrantless entry, but the Supreme Court overruled them, holding that the Fourth Amendment's protection against unreasonable searches and seizures extends to our homes, and that the physical entry into a private residence constitutes a significant invasion of privacy. In other words, the Supreme Court said the exact opposite of what Kristi Noem claimed under oath to Congress. And if the Supreme Court ruled that law enforcement needs real warrants issued by judges in order to enter a murderer's home, then they sure as hell need one to enter the home of a non-criminal who is legally living here under court supervision without his proper paperwork. And the most recent ruling on this issue was in this year of our Lord 2026. The courts continue to rule that Kristi Noem's interpretation of the law is wrong. But she's, spoiler alert, not the Department of Homeland Security Secretary anymore. She got her ass fired the day after that testimony, and I will get back to that later in this episode. But Todd Lyons, the acting director of ICE, he still remains. And he had no shame in his game when asked about his use of administrative warrants either. Here's Senator Richard Blumenthal of Connecticut questioning ICE Director Lyons on February 12th.
This picture is of ICE agents forcing their way into the Minneapolis home of Garrison Gibson, banging down the door, detaining Mr. Gibson in front of his wife, Tiana, and their 10-year-old daughter and niece who happened to be there at the time. I don't know whether you're familiar with what happened here. It's one of many, many, many similar incidents that have happened all around the country. And it was done pursuant to what is called an administrative warrant. I'm going to hold up a copy of that warrant. Signed by an SDDO, who is, I believe, a member of the ICE workforce, another agent, a supervisory detention and deportation officer, not a judge, correct?
Correct, Senator.
So, in effect, this is not a warrant, it's a permission slip. It's a green light from another ICE agent to go bash down a door, smash into a home, detain and arrest someone without a judge finding probable cause and without any sort of objective, independent finding. Is that correct?
No, sir. So the I-205 is the arrest warrant, but the I-205 is based on an executable final order issued by an immigration judge from the Department of Justice.
And that order is from an immigration judge who is part of the executive branch, not an independent judge. But the warrant issued is simply a permission slip. Now, let's be very clear. You were a local police officer.
Yes, sir.
To bang down a door, barge into someone's home, if you're the FBI or a local police officer, you need a judicial warrant from a judicial officer, a judge, who is going to find or not probable cause, which has a specific meaning under the law. These ICE agents are banging down doors, doing the same thing without that kind of judicial warrant. What is so different about ICE that it regards itself as an exception to the Fourth Amendment? And the requirement for a judicial warrant is a Fourth Amendment requirement.
We don't, Senator. There is case law, U.S. versus Lucas, 2007, which is out of the 8th District of Minnesota, which authorizes the entry of a home to catch a fugitive based on an administrative warrant.
I beg your pardon, sir. It does not abrogate the Fourth Amendment. It does not say that ICE agents or CPP agents can simply bash down doors and barge into people's homes, terrorize their children, detain and arrest people without a judicial warrant. And there is nothing different about what ICE does as compared to the FBI or local police that would justify it.
And here's why I'm calling bullshit, along with other legal experts whose words are in the show notes for you, and Senator Blumenthal, on the claim by Todd Lyons that U.S. versus Lucas,
which authorizes the entry of a home to catch a fugitive based on an administrative warrant,
and would therefore allow ICE to knock down the door of 28 people, including Garrison Gibson Brown, and forcibly remove him and others like him from their homes. I'm calling bullshit because U.S. versus Lucas was a case about a dude who had escaped from prison, and law enforcement, using a retake warrant for an escaped prisoner who was already in their custody, they entered someone else's apartment to rearrest that escaped prisoner. The warrant issued was specific to escaped prisoners. It wasn't even an immigration case. And so when you look at Garrison Gibson Brown's situation, he was not in law enforcement custody. He had not escaped from anywhere, certainly not prison. He wasn't breaking any law, and he was in his own home. It's a totally different situation. And the acting director of ICE using that case about an escaped prisoner as a justification for using administrative warrants in this way is an unacceptable twisting of law to get a desired outcome. That answer, in my mind, is grounds for immediate firing, because this guy, Todd Lyons, clearly doesn't understand the law or doesn't care and is not suitable for such an important leadership position. And we haven't even gotten to his memo yet. Here's Ryan Schwenk, our ICE lawyer turned ICE trainer turned whistleblower.
On my first day at the academy, I was instructed to read and return a memo in my supervisor's presence, which claimed ICE officers could enter homes without a judicial warrant. The acting ICE director authorized the very conduct that DHS, in its own 2025 legal training materials, had called the chief evil against which the wording of the Fourth Amendment is directed. That is, physical entry of the home without consent or a proper warrant. Never in my career had I ever received such a blatantly unlawful order, nor one conveyed in such a troubling manner. Incredibly, I was being shown this memo in secret by my supervisor, who made sure that I understood that disobedience could cost me my job. ICE is teaching cadets to violate the Constitution. And they were attempting to cloak it in secrecy by demanding that I lie about it.
And here are some more details about what the memo said and how it is being applied in ICE training.
So what the cadets were told to do was that they had the authority to make an arrest under this memo in someone's home, that they should knock on the door, and if the person did not open, as Miss Gibson Brown's family did, that they could use force to enter that home, reasonable force to execute the I-205 administrative removal order. That's what we were teaching cadets at the academy. That's what we were told to teach them. And I will tell you, when I taught my classes, I would tell the cadets that this policy existed, and I would tell them that they needed to check with their local office before they did anything, because there was no legal basis for this. But I did tell them this was the agency policy.
And here's why Ryan Schwenk taught the policy despite believing the policy to be illegal, as someone who had been an ICE lawyer for over 4 years. Here's Ryan Schwenk answering a question posed by Senator Richard Blumenthal of Connecticut.
Were you apprehensive that a failure to follow this illegal policy might result in demotion or discharge?
Yes, Senator, I was. In fact, it was made very clear to me when it was shown to me that if I did not follow it, I would probably lose my job. Two other attorneys for the agency had just been removed from teaching positions at the academy. One forcibly resigned. And the way it was shown to me or told to me was that it was because they disagreed with management over this policy.
But ICE made it impossible to debate the policy outlined in the memo with anyone with legal knowledge, because here's how that memo was being shown to the ICE trainers.
To my knowledge, this memo was never distributed to staff in general. In fact, when I came to the academy in September, I had never seen it despite being a counsel for the agency. I never saw it again after it was shown to me the first time, and maybe one other time when it was shown to me. Other than someone physically handing me the document, I never saw it again. And right before I left, I checked the repository where the agency keeps a copy of every official memo and policy guidance that is in effect, and there is no copy of it there. And Senator, I will point out to you, if we look at this document, if we look at it, every memo issued by ICE has a control number. It has something on it that indicates that it is an official policy document and where it falls in the agency's archives. And that's not on this document anywhere. Also, anytime we issue a memo, there is something in the document to control its release, something that says law enforcement only or for official use only, classified, secret, something. And there's nothing on this memo that says that. Nowhere on this memo is there anything that would let you know that this is an official policy of the agency. And to my knowledge, it's never been disseminated as one. It's been handed out piecemeal to people to use when the agency thinks they need to.
And if true, that indicates that Todd Lyons, the acting ICE director and author of the memo, knows the policy is illegal. That's the only reason I can think of that explains why you would want to keep a memo with training instructions secret. But it's not secret anymore. In fact, it's in the show notes for you if you want to see it for yourself. The memo starts on page 17 of the whistleblower disclosure document. And of course, when Todd Lyons, the acting director of ICE, testified to the Senate, Senator Richard Blumenthal asked about his memo. Senator Blumenthal brought it up in every Department of Homeland Security oversight hearing in February and March. Blumenthal's not letting this go. And here was the response from the memo's author, Todd Lyons.
The policy that they're acting under, in fact, is the result of a memo that you issued in May. You're familiar with it.
Yes, sir.
Has your signature.
Yes, sir.
Which says, in effect, they don't need judicial warrants. They can act on the basis of the 205 warrant that you've just described, which is administrative. It's not judicial.
Let's talk more about it.
Why did you keep this memo secret?
I didn't keep that memo secret, sir. It was blasted out.
We learned about it when 2 whistleblowers came to us and said that you were using it as a basis for the policy. It was never announced publicly. It was never released to the press or the American people. Why did you keep it secret?
Sir, I didn't keep it secret. If sending an email to a workforce of 30,000 people is keeping something secret, it's a bad secret.
It never reached those people.
Yes, sir, it did.
Well,
The email did, sir. Yes, sir. I can work with your committee to get your staff to get that.
But 2 weeks later, here's Senator Richard Blumenthal.
The same head of ICE who contended incorrectly about officer training also testified about the memorandum in which he announced the administration's new policy to invade American homes based on a permission slip signed by his own employees in violation of the Constitution, which was distributed to all ICE personnel. When I asked for the email distributing that memo, he assured me that ICE would produce it. They still haven't responded because the email doesn't exist.
And if it doesn't exist, that testimony from Todd Lyons would be perjury, which is a felony punishable by 5 years in prison. And it's certainly grounds for getting fired from a job that you were never confirmed by the Senate for in the first place. But Todd Lyons hasn't been fired. Kristi Noem, the Secretary of Homeland Security, has. But before you feel at all comfortable with a system that appears to be self-correcting, you should know that her firing had nothing to do with fake warrants or inadequate dangerous training, or even the uses of force that have resulted in the deaths of 2 U.S. citizens. This is what she was fired for. Here's Republican Senator John Kennedy of Louisiana questioning Kristi Noem in a public hearing on March 3rd in the Senate Judiciary Committee.
How do you square that concern for waste, which I share, with the fact that you have spent $220 million running television advertisements that feature you prominently?
Advertisements like this one, which featured Kristi Noem dressed like cowgirl Barbie riding a horse out on the plains.
Why do I love these wide open spaces? They remind me of why our forefathers came here, not just for its beauty, but for the freedom only America provides. I'm Kristi Noem. From the cowboys who tamed the West, to the titans who built our cities, to the dreamers who chased the impossible, America has always rewarded vision and grit. Our greatness calls people to us for a chance to prosper, to live how they choose, to become part of something special. Anyone who searches for freedom can always find a home here, but that freedom's a precious thing, and we defend it vigorously. You cross the border illegally, we'll find you. Break our laws, we'll punish you. Harm American citizens, there will be consequences. But if you come here the right way, your American dream can be as big as these endless skies. From President Trump and me, welcome home.
Those ads cost us $220 million in our tax money to produce, which for context is the same budget as the Avengers. And Senator Kennedy pointed out where that money went.
My research shows that you did not bid them out, that you pick, in fact, one of the people you picked, the strategy group, Safe America Media was a company formed 11 days before you picked them, and that the strategy group got most of the money, and the head of that is married to your former spokesperson.
Doesn't look great. And here's how she defended that budget and the ads to Senator Kennedy.
Sir, the president tasked me with getting the message out to the country and to other countries where we were seeing the invasion come from, with putting commercials out that told them that if they were in this country illegally, that they needed to leave, or we would detain them and remove them, and they'd not get the chance to come back to America the right way. That has been extremely effective.
Ask you to run these advertisements, is that right?
We had that conversation, yes, before I was put in this position and sworn in and confirmed, and since then as well.
The president approved ahead of time you spending $220 million running TV ads across the country in which you are featured prominently.
Yes, sir. We went through the legal processes, did it correctly, worked with OMB.
Do this?
Yes.
He did?
Yes.
Okay.
So she blamed the whole thing on President Trump. And when Senator Kennedy, after the hearing, asked President Trump about those stupid ads and told Trump that Kristi Noem said that he had personally approved of them, Trump got, quote, mad as a murder hornet, unquote, according to Senator Kennedy. And then Trump fired Kristi Noem the next day. Basically, she got fired for damaging the fragile ego of Donald Trump. Her constitutional violations had nothing to do with it. Which is why Todd Lyons remains as the head of ICE. And if you think Trump's new pick for Secretary of Homeland Security, if confirmed, is likely to make substantial changes, well then, you don't know Macho Man Mark Wayne Mullen. Mark Wayne Mullen is currently a senator representing Oklahoma, and he's best known as a former MMA fighter who threatened, mid-hearing, to fight a witness. He challenged Sean O'Brien of the Teamsters Union essentially to a duel, and it was a fight that was stopped by then 82-year-old Bernie Sanders.
Sir, this is a time, this is a place. If you want to run your mouth, we can be two consenting adults. We can finish it here.
Okay, that's fine. Perfect.
You want to do it now?
I'd love to do it right now.
Well, stand your butt up then.
You stand your butt up.
Oh, hold on.
Big guy.
No, stop it.
Is that your solution, everybody?
No, sit down. Sit down.
Okay.
You know, you're a United States Senator. Sit down.
Active.
Oh, okay. Sit down, please.
All right.
That's Senator Mark Wayne Mullen. And after Alex Preddy was shot in the back while being restrained by a bunch of Department of Homeland Security dudes, Senator and possible Department of Homeland Security Secretary Mark Wayne Mullen said,
Unfortunately, a deranged individual that came in to cause max damage with a loaded pistol with an extra mag that was completely loaded was shot and killed. Now, how much more does this got to go on before the Democrat leaders there take responsibility for their words?
So do you think that's a guy who's going to hold ICE accountable? Or do you think he's likely to continue to defend them no matter who they murder and how many of us can see the video? And this concerns me because the changes are going to have to come from the top if they come at all. Because again, Todd Lyons, the head of ICE, despite the possible felony perjury and the almost definite violations of the Constitution, he's still in charge of ICE. And he isn't open to even basic changes to ICE policy to bring them in line with all of the other law enforcement standards in this country. Here's Todd Lyons responding to a question from Representative Tim Kennedy in the House Homeland Security Committee on February 10th.
Will you commit, yes or no, to immediately unmasking every agent conducting immigration enforcement and requiring them to wear standard uniforms with identifiable badges?
No.
He's promising no changes and defending the worst, most unconstitutional actions of ICE, defending them to the point of possibly making himself a criminal in the process. And so if ICE is going to change on its own, it's got to be from either President Trump or a new Department of Homeland Security secretary who's going to force those changes. And there's no sign of that on the horizon, which means that the changes need to be forced by the courts and by Congress. And the courts are doing their part. They have ruled over and over again that ICE is violating the law. But the law enforcement branch is the criminal here, so who's going to enforce those rulings? That only leaves Congress, which brings us back to the damn Republicans, who refuse to even officially hear whistleblower testimony. Forget about doing anything about it. You know, when the history books are written, I believe with every fiber of my being that the Republicans in Congress will go down as the greatest villains of this era, because it is their job to remove criminals from the law enforcement branch. They're the only ones who can, and they refuse to do it. Congressional Republicans are running cover for the Trump administration instead of doing their jobs and making sure that it follows the law. They are hiding information from the American public by refusing to bring these ICE hearings out of the shadow and into the official congressional record. They are putting loyalty to their party over loyalty to the Constitution, which every single one of them took an oath to defend. They swore an oath to defend the Constitution, not the administration of Donald Trump. And you know that I've always taken pride in calling balls and strikes fairly when I see them as I analyze Congress. Longtime listeners know that I have aimed my verbal cannon at members of both parties. And if you want a recent example of me aiming it at the Democrats, listen to any episode about the 2025 shutdown. And it's in that spirit that I say this. The Republican Party does not deserve to keep more than a handful of seats in the 120th Congress. I personally would keep Tom Massey, Brian Fitzpatrick, Rand Paul, and Lisa Murkowski. That's it. The rest of them deserve to be shown the door. This shadow hearing should have been official. And if we empower Democrats with our votes this November, hearings like this will be official. And I know this to be true because of their actions. There have been 3 shadow hearings conducting oversight of ICE by Democrats and Democrats alone in the last 6 months. That's action, not just words. And it's one of the rare instances in the 119th Congress of me seeing something that I want more of. And I know exactly who will give it to us. And so that's why I have no fear of sounding partisan, because at this moment, I guess I am. Because of the job performance of congressional Republicans. It's the worst I've ever seen. They deserve to be fired en masse, and my hope is that we do so. Because with Republicans out of power in Congress, that's how we can remove Todd Lyons and other lying, Constitution-shredding members of this administration. Those are the stepping stones to accountability. We have to take Republicans out of power in Congress in order to remove the bad apples in the Trump administration. And we have to do this because our most basic rights are at stake. So as I've been recording this episode, well, 2 things are going on during the recording of this episode. One is South by Southwest has been happening outside my window. And so if you've heard helicopters and sirens and music and general chaos, I couldn't control that. So I'm sorry if you could hear that in the background. But also happening in the background of this episode is the Department of Homeland Security is shut down, and it has been shut down for weeks, and it does not appear that we are any closer to reopening it. And so I want to give you an update on that, which is that the Democrats have offered to fund every agency in the Department of Homeland Security immediately. There are 22 agencies in the Department of Homeland Security. They are willing to fund 21 of them, with the exception being ICE. And the reason they are not willing to fund ICE right now is, first of all, ICE got plenty of money in the big, beautiful bill. So ICE is actually not shut down right now. So that's one of the reasons. But also they want some basic restrictions placed on ICE's behavior. And so if you are pissed at very long TSA lines, just know that the Democrats have put that option on the table, and it's the Republicans who are refusing. And I do have to say that it is so unfair that TSA agent paychecks are being held hostage for something that has nothing to do with them. You know, blowback for our interference in the Middle East came in 2001 in the form of hijacked airplanes. That's what TSA was created to prevent after 9/11. And so withholding their paychecks while simultaneously starting a war that is quickly spiraling out of control in the Middle East, it's just about the stupidest, most dangerous thing we could do. And once again, we are seeing that shutdowns don't work, especially the way the Democrats do it. Because while I fully support forcing ICE to get judicial warrants to enter our homes, which is one of the Democratic Party demands, along with forcing ICE to take off the masks, wear identification, and stop roving patrols where they harass anyone they choose. You know, basically, Democrats are demanding that ICE be held to the same basic standards as every other law enforcement agency in this country. I support it 100%. But when the Republicans in the House of Representatives went on vacation twice during this shutdown, the Democrats went home too. The Democrats haven't been staging sit-ins on the steps of the Capitol every day, and they haven't been appearing on every news station and on every podcast, making their case for ICE reforms to the American people. No, they went on vacation too. And the result is, like, I saw a post this morning on Instagram showing the crazy long TSA lines at Austin Airport this morning. And out of 190 comments, yes, I read them all, only a handful of those commenters blamed the shutdown. Most people here in Austin blamed spring break and South by Southwest. And so if Democrats are going to play the shutdown card, they should at least attempt to play it effectively. But they aren't doing that. People aren't even aware of why the shutdown is happening. And so I'm convinced the Democrats are about to lose this fight too, just like they lost the last one with the 2025 shutdown. I just hope that we don't lose an airplane full of people in the process. I hate this Congress so much. So much. Even the people fighting the good fight are doing it like goldfish in a boxing ring. But we are doing what we can, right? We are creating this podcast. We are spreading the word about the illegality so that hopefully in November, some people will get angry enough to fire the Republicans. That's the only hope I have right now. And so I want to thank specifically our executive producer on this episode, Adam Selby. He contributed $535 to put a credit on this episode. And I'm actually really happy that you did that because this episode, I think, deserves to go to the top of the list. This is one of the most important ones that I've done. But yeah, thank you, Adam. And thank you to every other executive producer and producer, every single person that's helping me create this show. And thank you to everyone who is spreading the word, who is sending this podcast to your friends, who is forcing them to listen to it in the car with you, who is doing what you can to grow the reach of the show and to keep it going long term. I am hopeful that if we do get Democrats in control of even part of Congress next year, that we'll get more hearings like this and we'll learn a lot more about what's going on. I mean it when I say that I am as bad as the Democrats are in so many ways. Like, look at the shutdown. This was a really important hearing and they've promised to do more of them. So there's a little bit of hope for you. But I also want to thank Claire, who is my production and research assistant. While I was away at a wedding this last weekend, I was firing off a bunch of sound clips that I wanted from her because Kristi Noem was fired after I had collected all the clips from this episode. So Claire did a lot of the heavy lifting on those clips we played for you at the end, explaining Kristi Noem's firing and telling you about Mark Wayne Mullen. So thank you, Claire, for stepping up over the weekend for that. Thank you, Mike at Pro Podcast Solutions, who makes me sound like I don't have marbles in my mouth. Thank you to Mark at podcastbranding.co, who keeps our website up and running despite all of the attacks that we do get from people wanting to take it down. Thank you to my sister, Lauren, who keeps track of all of our executive producer credits and does my bookkeeping. Thank you to Dad and Robin, who do my taxes. And thank you, as always, to our guardian angel, Brian Karras. We will miss you and your art forever and ever. All right, the next project here is I am going to give you a summary of February. That project is a bigger bitch than you would think it is because we funded some of our government in February. And so I need to find the secrets in that funding bill for you. And I will get that done by the end of the month. Okay. I don't know if you can hear this, but South by Southwest has begun again. And so I am going to get dressed and go join the fun. I suggest you do the same thing because this was a heavy episode. But thank you as always for staying engaged and for listening. And I will talk to you soon. Take care. Bye.
We're surrounded now by liars coming at us through our TV screens.
We don't have a domestic spying program.
They're content to fight in black and white despite the many in-betweens. We got a president who plays with the facts. And then he waves a flag to cover his tracks. As if a lie is alright, if the end will justify the means. Now we are so damn tired of being lied to.
The polar ice caps aren't going away.
We don't think we can deny it anymore. You can stick to your story if you think it flies. But we're not keeping quiet anymore. We are so damn tired of being lied to.
Government jobs consume the profits of the private sector.
We don't think we can deny it anymore. You can stick to your story if you think it flies. But we're not keeping quiet anymore. Now we're not keeping quiet.
These bills represent common sense, bipartisan solutions that actually solve problems.